Good morning. Today in this video clip we will see the proposed amendments to the Constitution, which is known as 20th Amendment to the Constitution. It was published in the Government Gazette, and to inform to the public that the government going to bring this amendment very soon. When you see this proposed draft, clause 1, as usual, this act may be cited as 20th Amendment to the Constitution. There is no issue at all. Then we will see the clause 2. The clause 2 amends Article 31 of the Constitution, especially Article 31, paragraph 3A, subparagraph A, subparagraph 1 of the Constitution. Certain words substituted by this amendment. For the words by election for further term, now it is substituted by election for a second term. This is done for clarity. Really speaking, there is no legal effect to this amendment, because already by 19th Amendment it was provided, like if a person who held the office of the president for 2 terms is disqualified from contesting third time. Now it's more clearly, without saying for a further term, now it is clearly said for a second term. Therefore, it is limited now. Only a person who can hold the office as a president for only 2 terms. Then this is an amendment made here for clarity purpose, not for anything else. There is no legal effect of this amendment. Now we will see the clause 3 of the proposed draft. Article 33 of the Constitution repealed and replaced. Then we must see the differences between the existing one and the proposed one. When you see this difference, first of all, the existing one, it shall be the duty of the president to ensure. There are 4 duties given to the or imposed on the president of Sri Lanka. The first one, ensure that the constitution is respected and upheld. Second one, the promote national reconciliation and integration. Third one, ensure and facilitate the proper functioning of Constitutional Council and the institutions referred to in Chapter 7A. Finally, on the advice of the Election Commission, ensure the creation of proper conditions for the conduct of free and fair elections and referenda. These are the duties imposed by 19th Amendment first time. Now those duties again repealed or removed. That's why the whole section removed and substituted again. When you see the proposed section, Article 33, sometimes I'm using the word section, but all these things are articles. Article 33 of the Constitution now substituted here. When you see Article 33 of this proposed one, in addition to the powers and functions expressly conferred or assigned to him by the Constitution or other written law, this is additional powers. Really speaking, the powers given to the president by the constitution and other written law. In addition to that, there are certain powers given here also. Right? Now when you see these powers, that all whatever powers given in the existing provisions now again substituted in the proposed draft, except one, that is paragraph C, now removed. What is the paragraph C here? President shall have the power to summon, prorogue and dissolve parliament. Now this section is in section 70 of the Constitution. When you see the section 70 of the Constitution here, Article 70 of the Constitution provides that the President may summon or prorogue or dissolve Parliament. Now, even though the paragraph under Article 33 repeal, but there is a provision in the Constitution itself provides that President shall have the power to, or President may dissolve, summon, prorogue the Parliament. Therefore, even though it is an amendment or omission of this paragraph, there is a separate article which has given the power to the President to hold these, to summon the Parliament and prorogue the Parliament and dissolve the Parliament. Now we will see clause number 4 of the draft. When you see the clause 4 of the proposed draft amendment to the Constitution, 33A of the Constitution hereby repealed. 33A of the Constitution provides that, I will read the section first. The President shall be responsible to the Parliament for the due exercise, performance and discharge of his powers, duties, functions under the Constitution and any other written law, including the law for the time being relating to public security. Now, because of repealing the Article 33A of the present Constitution, it doesn't mean that President's responsibility is removed. I noticed certain medias said that now the President has no responsibility towards the Parliament, but it is not like that at all. There's a mistake. Now, when you see Article 42 of the Constitution or the proposed Constitution or the proposed amendment or 20th Amendment here, it provides that the President shall be responsible to the Parliament. Without reading the whole amendment to the Constitution, certain people have come to the conclusion that now the President has no responsibility towards Parliament. But it is wrong at all. Article 42 of the proposed amendment provides that President is responsible to the Parliament. Now we will move to clause 5 of the proposed 20th Amendment. Again, clause 5 repealing the Article 35 of the Constitution and substituted a new one. But when you see the difference, that's the real matter here. When you see the paragraph 1 of Article 35, it's similar section or same paragraph is in the existing one. Only things here, the proviso 1 and proviso 2 removed or repealed in the proposed amendment. Then those are the very important amendment that we must look into. When you see this proviso, or I'll read the whole section because that's more it's good for understanding. While a person hold the office as a president, while any person holds office as a president, no proceeding shall be instituted or continued against him in any court or tribunal in respect of anything done or omitted to be done by him, either in the official capacity or private capacity. The same wording, same paragraph is in the proposed draft also. Then the omission part is the proviso 1 and 2. There are two provisos given to this one. The first proviso, provided that nothing in this paragraph shall be read and construed as restricting the rights of any person to make an application under Article 26, that's the fundamental rights, against the Attorney General in respect of anything done or omitted to be done by the President in the official capacity. Again, second proviso, then section says you can't file an action, any civil or criminal action. Then the proviso says you can file an action in relation to the violation of fundamental rights. And again, proviso, it must say in certain cases you can't file an action against the president. Then further proviso, the second proviso says, provided further that the Supreme Court shall have no jurisdiction to pronounce upon the exercise of powers of the president under Article 33 2G, that is the power of the president to declare war and peace. But only in relation to that one, any person cannot file an action in the Supreme Court. But in relation to any other fundamental rights violation, that's Article 126 provides to file an action in the Supreme Court, that's permitted. But now it is repealed. Therefore, there may be an impression that you can't file an action against the president in any circumstances. But it is not like that, because there's a determination given in relation to the 17th Amendment by the Supreme Court, that I'll read the paragraph here. In terms of Articles 3 and 4 of the Constitution, the fundamental rights and the franchise constitute the sovereignty of the people and is inalienable. The Constitution does not attribute any unfettered discretion or authority to any organ or body established under the Constitution. Even the immunity given to the President under Article 35 has been limited in relation to the court proceeding specified in Article 35(3). Article 35(3) in the existing one as well as the proposed one similar. In certain circumstances, the action may be filed against the president directly without any restriction or without any restriction given in paragraph 1. That's why he has said that the first thing is, there are two things I would like to mention here. The first thing is, while any person hold the office as a president, no proceeding can be taken. Then after that period, the action may be taken against the president, one thing. The second thing is, immunity conferred on the provisions of paragraph 1 shall not apply in the certain circumstances specified in paragraph 3 of that Article 35. Right? That's when the court further said that, moreover, the Supreme Court has entertained and decided the questions in relation to the emergency regulation made by President Joseph Pereira versus Attorney General 1992, 1 SLR, page number 199. And the president's appointment, that also challenged, and the Supreme Court entertained and decided. Silva versus Bandaranaike, 1997 1 SLR, page number 92. In those two circumstances, even though the immunity given to the president, Supreme Court entertained and decided. Therefore, the immunity, whatever given, fundamental rights always there. Then we will move to the clause 6. Clause 6 repeal the 7A, chapter 7A of the Constitution and replaced or substituted another new one. Now, presently we have the Constitutional Council that is substituted by Parliamentary Council. The Parliamentary Council consisting of 5 members. As you know, that 17th Amendment established Constitutional Council. Again, the 18th Amendment removed the Constitutional Council and substituted Parliamentary Council. At that time, it was challenged. But the challenge on so many grounds, but the main ground in relation to the Parliamentary Council here, the learned counsel for the petitioner contended that the provisions contained in the clause 5, now here in the proposed amendment, clause 6, have the effect of diluting the independence of the judiciary and therefore has a direct impact on Article 4C. The judicial power should be exercised by the Parliament through the courts. That is Article 4C. Regarding the exercise of judicial power of the people and sovereignty of the people in terms of Article 3 and Article 3, and therefore requires to be approved by the people at the referendum in terms of Article 3. This was an argument at that time, but court refused this argument, and also the court said that the same wording. I would like to read this one because now the present proposed amendment also same provisions again brought into again intended to bring to operation. Now when you read this paragraph, the present amendment refers to the introduction of Parliamentary Council in the place of Constitutional Council, which consists of Prime Minister, Speaker, Leader of Opposition, a nominee of the Prime Minister who shall be the Member of Parliament, and a nominee of the Leader of Opposition who shall be the Member of the Parliament. The persons appointed as nominees of the Prime Minister and the Leader of Opposition should be nominated in such manner as would ensure the nominees would belong to the communities which are communities other than those to which the Prime Minister and the Speaker and the Leader of Opposition would belong. On the consideration of totality of the provisions dealing with the establishment of Parliamentary Council, it is clear for the reason aforesaid that the proposed amendment is only process of redefining the restriction that was placed on the President by Constitutional Council under 17th Amendment in the exercise of executive power vested in the President, which is inalienable. Therefore, 17th Amendment brought into operation of Constitutional Council. That one repealed by 18th Amendment and substituted the Parliamentary Council. The same situation now again here now. 19th Amendment introduced the Constitutional Council as it was in 17th Amendment. Again, the 20th Amendment reintroducing the Parliamentary Council in the place of Constitutional Council. The same argument will stand even now, or same determination will stand even now. Now I think we'll stop with this one for the time being. and thank you very much.